Sixth Amendment. Right, the Fifth was pretty fast. Now, in Intro to Criminal Justice, the Sixth Amendment has 6 things that we are concerned about, not nearly so many in corrections. Sixth Amendment, the speedy trial. Speedy trial in other criminal cases. Most of our offenders are not one-stop shoppers. So you might have a guy sitting in prison doing time on, say a Saginaw County armed robbery. But this individual also committed an armed robbery in Tuscola County. So now he's doing, 10 to 20 on the Saginaw County charge. Tuscola County has just filed their charges. The case is pending. The prosecutor in Tuscola County cannot say, well, since he's doing 10 to 20 on the Saginaw County charge, he isn't going anywhere in any hurry. So why don't we just move him to the back of the line and we'll deal with all these other cases first? Well, what the Sixth Amendment means is that this person has to be processed through the courts in exactly the same order they would have otherwise. You can't move them to the back of the line just because they're serving time. Access to courts and counsel. Now this is pretty simple. All it really means is that the prisoner has a way to communicate with the courts. And guess what? It doesn't have to be in person. It doesn't have to be by telephone. It doesn't have to be by email. It can be in good old-fashioned writing. As long as they have a way to send a letter and communicate with the courts, we're done, we're covered. Now what can happen is the prisoner says, well, I'm indigent, I have no money. Nobody loves me, nobody sends me money. I have no money at all. I can't buy writing materials from the prison commissary. I can't afford to buy ink pens or envelopes or stamps. So I have no access to the courts. And we go, not a problem. So if they're indigent, we will provide for them postage and writing supplies. Now, different facilities vary in how much, but rule of thumb is usually 2 or 3 a month. 2 or 3 pieces of paper, 2 or 3 envelopes and stamps, and something to write with. Now, if they choose to use those writing materials for another purpose, well, that's entirely on them. But we have met our burden. We've covered our butts here, and if this inmate desires to communicate with the courts, well, now they can. See how that works? Access to an attorney. Mostly this just relates to jail inmates. Since most inmates are poor and cannot afford an attorney, then once their case is concluded, their public defender, their appointed attorney, is no longer their attorney. They're done. So unless you've got money and you've got an attorney on retainer or something, once you're in prison, it's pretty wonderful. But, just in case, whether you're in jail or in prison, that you can have access to your attorney by phone, by mail, and by visitation. And by phone, we cannot listen in on your phone call. By mail, we cannot read your correspondence with your attorney. And by visitation, we cannot count any visits from your attorney against your visiting quota for the month. So let's say, for example, a prisoner is allowed 5 visitors a month, and their attorney comes to see them 3 times. Well, we're not going to say, well, you only have 2 visits left. No. They still have all 5 visits. We're not going to count that against them. If they have an attorney. If they don't, the courts have ruled that in lieu of an actual attorney, inmates may make use of assistance from what we call jailhouse lawyers. Who could tell me what a jailhouse lawyer is?
An inmate who is self-educated.
Yes, an inmate who is self-educated in the law. They have spent time in the law library educating themselves on the finer points of the law. And some of these guys are really good. Some of these guys are as good as any attorney. So the courts have said, well, you know, if you don't have an attorney because you have the public defender, you're indigent, and you have no other means of legal access or assistance, you may make use of one of these jailhouse lawyers. And prison staff can't stop you from doing it. Access to courts and counsel also means access to legal reference materials. So if you're a prisoner, you're in prison, you're preparing your appeal. You're going to allege an error of law in your case, and you want an appeals court to hear you out and say, yes, there was an error of law. Well, you need to prepare your case, right? So in prisons, it basically means law libraries. Some of the finest law libraries around found in our prisons. Even nicer than the ones in our universities sometimes. Now with the advent of technology, they have been able to do away with the expensive books and the bulk of books. I mean, you can imagine, books are really expensive. You guys in college wouldn't know anything about that, would you? Yeah, books are expensive, and now they're actually able to put them on digital files. So it saves a lot of money and a lot of space now. But the inmate has to have access to that. And legal advice, which may include your jailhouse lawyers.
I have a question.
Yes?
Now, the code of ethics says that you're not allowed by law to practice law without a degree.
Yes.
How are they able to give legal advice without having a law degree?
Who's going to sue them? I mean, they're not saying that they are attorneys. So, as long as they're not saying that they're attorneys, then, you know, it's caveat emptor, right? Let the buyer beware. Moving right along. That's the 5th and 6th, pretty easy, huh?